Thanks, Gavin. That's all a bit over the top. Last November, I was invited to make the opening remarks at the Australia and New Zealand Legal History Society's annual conference. The theme of the conference was intersectionality and legal identities. Perhaps many of you are familiar with the concept of intersectionality. The term is attributed to Kimberlé Crenshaw in an early essay about the intersection of race and sex. Professor Crenshaw contended that both law and public political advocacy would continue to fail multiply burdened individuals if they failed to take account of the different identities of those individuals. The essay was about black female plaintiffs who failed to obtain legal redress under US discrimination statutes because they could not prove that their employer had discriminated against them on the ground of either race or sex. As I understand it, the plaintiffs failed because there was no evidence that the employer discriminated against white women or against black men. Professor Crenshaw's work in highlighting an odious situation was no doubt important. One would expect in this country that if proof of the requisite standard was adduced that an employer treated black women less favourably than white women and black men, that would show discrimination on both grounds. Professor Daniel Hosang of Yale says intersectionality is now a stranger to the place where it started. It is at the heart of what's now called identity politics. Others have described it as a buzzword for wokeness bandied about by people who do not understand it. But as I walked to the podium that Friday morning, with that theme appearing behind me, the words of the psalmist drifted through my consciousness. "You have prepared a table before me in the sight of those who trouble me." My topic was useful legal history, and somewhat to my surprise, it seemed to be well received. So I thought I would investigate whether King David's next prediction, that goodness and kindness shall follow me all the days of my life, would come to pass, and I have in some ways reworked the paper. This is a further variation then on the same theme, but I've augmented it with some of the things I learned at that conference and subsequently. And it's focused, given the theme of this august body, on some aspects of what are referred to as constitutional human rights. Can I begin by saying something about the law? As an intellectual exercise, the discipline of the law is an analysis of human behaviour. It is perhaps the oldest surviving such analysis. It predates the social sciences, the economic and class-based approaches, and the various modernist, postmodernist and post-postmodernist approaches. Now, when we're past the half-life of many of those decaying disciplines, the analysis of the law continues. And this is due, I think, to its usefulness in resolving disputes, and so in allowing relatively peaceful and free societies to continue. There is a simplicity to the law. It is concerned with two fundamental questions about human conduct. What happened and what does it mean? What happened is always an historical inquiry. What does it mean often requires knowledge not only of the circumstances in which events occurred, but also of any previous understanding of conduct of that kind. Michael Kirby recently contributed a foreword to a legal history text, and his contribution was rather pessimistically titled Decline and Fall. But there he observed, unless Australian lawyers have a good hold on the main outline of English, imperial and American legal history, they will not readily see the way that any particular legal category or constitutional or statutory text fits into the large mosaic of Australian history. Finding and applying legal rules necessitates an appreciation of their context. A young lawyer deprived of a background briefing on the contours of legal history will be like a surgeon who suffers with cataracts. They will see the immediate text in a blur, but they run the risk of failing to appreciate its context and purpose, the things that add precision and sharpness to one's understanding. Those remarks echo similar words by Patrick Keane, writing 10 years ago extrajudicially. He said, "I do not accept that stable solutions to legal problems are apt to emerge from the application of the logical and rhetorical skills of even the most talented debaters, as if the exercise were a matter of first impression. I have no doubt," he said, "that the law must evolve to enact changing circumstances, but continuity and regularity are fundamental values which inform the rule of law. The fundamental ethos of the judicial arm of government is that justice requires that like cases should be treated alike. The just resolution of a legal problem between the state and a citizen or between citizens is not a process that starts afresh each time a lawyer is called upon to address a legal problem. If the common law is nothing more than today's correction of yesterday's error, then there would be little reason to value it, and certainly no reason to fight for it." May I take you on a small excursion then through some of the moments in the history of human rights and the law in this country. As Bruce McPherson noted in his reception of English law abroad, by the time of European settlement in these lands, Sir Edward Cook's view was commonly accepted that men and women of whatever state or condition had the liberties declared in Chapter 29 of Magna Carta, in the form sealed by, I think, the infant King Henry III, including the right not to lose life, limb, liberty, property, ability to remain in the kingdom, or to suffer any penalty except by the lawful judgment of his or her equals in accordance with the due process of the law. Blackstone called these rights absolute. They were rights to personal security, personal liberty, and private property. Early in the 14th century, it had been established that the monarch could not unilaterally alter the law, and in the 15th century it was certain that the king without parliament could not deprive a subject of the common law, including the common law rights and immunities. The principle then of lex rex over rex lex, that is, the law is king and the king is not the law, was finally settled by the great legislative achievements of the 17th century. The Petition of Right, the Habeas Corpus Act, the Bill of Rights, and then in 1701 the Act of Settlement. These, together with Magna Carta, comprised a set of personal immunities which Blackstone explained were formerly the natural rights of all mankind, but remained the rights of English people. The common law also enshrines important presumptions that protect substantive rights through the canons of statutory interpretation. This includes a presumption that Parliament did not, unless expressly stated, intend to limit personal liberty or freedom of speech. The principle of legality means Parliament must squarely confront what it is doing and accept the political cost of affecting people's rights. Fundamental rights cannot be overridden by general or ambiguous words. When Australia's founders were putting together our constitution, there were one of the most influential documents in addition to that tradition was the US Constitution. It is said that a copy of James Bryce's The American Commonwealth was placed on the table of the debating chamber through each of the conventions, and some delegates drew upon it. Since 1791, the US Constitution had incorporated a Bill of Rights in the form of the first 10 amendments, and of the subsequent amendments, perhaps the most significant was the 14th, made in the aftermath of the US Civil War. In February 1898, at the Melbourne session of the Australasian Federal Convention, the inclusion of a clause 110 in the draft constitution was debated. It had been prepared by Tasmania's Attorney-General, Andrew Inglis Clark. And for present purposes, it read, "A state shall not make or enforce any law abridging any privilege or immunity of citizens of other states of the Commonwealth, nor shall a state deny a person within its jurisdiction the equal protection of the laws." A clause to this effect had been included in all of the earlier drafts of the Constitution adopted at the previous conventions. And the New South Wales Legislative Assembly and the Tasmanian Legislative Council had proposed a similar, if more limited, clause that a state shall not deny to any person within its jurisdiction the equal protection of the laws. Part of Clark's clause did find its way into our Constitution as Section 117, which is the prohibition on discrimination by one state against the citizens or the residents of another. But in 1898, Clark, who had recently returned from a visit to the United States, was quite taken by the 14th Amendment, or at least Section 1 of it, and he urged the inclusion of an equal protection clause. That clause in the US Constitution, I just pause to note, since the Second World War, has been very frequently litigated, and many of the cases that stand out as landmarks of 20th century US jurisprudence, like Brown and the Board of Education, Roe and Wade, Reed and Reed, University of California and Black, and Bush and Gore, of course, and in this century, the outstanding cases about gay marriage and about affirmative action at Harvard and the University of North California also draw on that amendment. But in 1898, the effect of the American Equal Protection Clause was not understood as it is today. That was the time when the decision of Plessy and Ferguson prevailed. In it, by a majority of 7-1, the US Supreme Court had held that the 14th Amendment was never intended, quote, to abolish distinctions based on colour or to enforce social as distinguished from political equality. That judicial view would prevail in America for nearly 60 years until it was overturned by the Supreme Court in Brown and the Board of Education. At the Melbourne session of the convention, Richard O'Connor supported the clause drafted by Clark. No doubt he was aware of the Plessy decision, and he told the convention delegates that Clark's clause would not prevent states enacting laws that differentiated between individuals on the basis of race, but would operate only to ensure what he called equal administration of the law. Clark was not well enough to attend the Melbourne Convention. From his sickbed, he wrote to suggest an amendment to his own clause to exclude quite expressly from the Equal Protection Clause, quote, all persons of Asiatic blood who have not been specially naturalised. At the convention, Isaac Isaacs led the charge against the Clark Equal Protection Clause. He described it as a very dangerous proposal that what became the High Court would control the legislatures of the states within their own jurisdiction. Isaacs also challenged the delegates to identify any of the Australian colonies that had ever deprived a person of life, liberty or property without due process of law. The former Premier of South Australia and strong supporter of women's suffrage, Dr John Coburn, and his fellow South Australian delegate John Gordon, another man of the progressive left, opposed the Clark Clause on the basis that it reflected poorly on what he called Australasian civilisation to think that such a clause was necessary. The common law provided the protections that ought to be in place. In the end, that part of the clause was defeated by 23 votes to 19, and so it does not appear in our Constitution. The absence of an equal protection clause, particularly one that might have been blemished by an amendment like that Clark himself suggested, left the common law inheritance intact. And the right to due process is protected under our laws with the High Court holding it to be a fundamental element of the judicial power beyond the reach of the executive or the legislature. In retirement, Sir Owen Dixon explained that the history of Australia had not taught the framers of the Constitution that there was a need for provisions directed to the control of the legislature itself. And in Australian Capital Television, Sir Anthony Mason expressed the same view. The Constitution did include some protections. There was a prohibition on the Commonwealth establishing a religion or imposing a religious observance, prohibiting the free exercise of religion, or imposing a religious test for any Commonwealth or public trust office. That provision was necessary because it was unknown to the common law. The Commonwealth's power to acquire property was limited to acquisitions on just terms, and the shortcomings of the common law process for judicial supervision of public officials that had been identified in America by Chief Justice Marshall in Marbury and Madison were remedied in a way that was proposed by Clark. This provided a basic guarantee of the rule of law in our Constitution. And of course, the right to trial by jury on indictment for Commonwealth offences was included, as was the freedom of interstate trade, commerce and intercourse. And this is the way things were for at least the first 40 years of the Federation. In Australia's wartime Curtin government, the then Attorney-General, Dr. Evatt, brought forward a referendum in 1944 to include in the Constitution what were called the 14 powers or the 14 points. This proposed to grant further power to the Commonwealth for post-war reconstruction. Late in the progress of that proposed measure through the Parliament, Evatt secured amendments to include a prohibition on the Commonwealth or any state enacting a law abridging freedom of speech or expression, and to apply the non-establishment and religious freedom clause of the Constitution to the states. Australian electors were not given a choice on each change that the Commonwealth sought in this measure. It was a single yes or no vote to the entire package. In the official yes case, the government described the democratic safeguards as providing, quote, freedom of speech and expression, freedom of worship, and greater control by the people's representatives of government by regulation. The measure was carried in Western Australia and by a slim margin in South Australia. It was rejected overall and in each of the other states. Here in Queensland, perhaps most emphatically, with 63.5% of the electorate voting no. Another constitutional alteration referendum was conducted in September 1988. It would have extended existing rights relating to religious freedom, compensation for the acquisition of property, and trial by jury to the states. It also included a proposal for what was called one vote, one value. All of the proposals put to referendum were defeated nationally and in every state. It was a dismal result for the proponents of change. The highest national yes vote reached 37% for the one vote, one value proposition. And the so-called guarantee of basic freedoms proposal received really an astonishingly low vote. Nationally, 30.33% favoured it. It was the lowest yes vote ever recorded in an Australian referendum. In South Australia, the yes vote was only 25%, as it was in Tasmania. So that is what's happened in terms of constitutional entrenchment of human rights in Australia. Can I say something about the next level down from that, which is legislative change? The Second World War and the response which followed it brought into existence the United Nations and its agencies and led to the ratification of the Universal Declaration of Human Rights by the General Assembly in 1948. In recognition of the differences in historical, political, legal and cultural backgrounds of the member states, the implementation of human rights treaties, including the Universal Declaration, was left to national governments. Sovereign states reserved the right to implement human rights treaties as they saw fit. Each state elects which of the provisions may or may not be legally enforced in its domestic law, and also the manner by which they may be enforced. In November 1973, the then Attorney-General, Senator Lionel Murphy, introduced a Human Rights Bill and the Racial Discrimination Bill into the Commonwealth Parliament. These measures sought to enact certain international rights covenants and conventions as Australian domestic law, using the Commonwealth's external affairs power. According to Senator Murphy's second reading speech, the Human Rights Bill, the state of liberty and Australia's, quote, supposed commitment to freedom, unquote, were not at all what the common law would comprehend. He spoke of, quote, the basic human rights of a full and satisfying life. And in essence, it was a right to government welfare for those who, in his words, do not enjoy the full measure of human rights and dignity. The Human Rights Bill lapsed. The Racial Discrimination Bill was enacted, becoming law in 1975. And it was followed by other legislative measures, the Sex Discrimination Act and the Human Rights and Equal Opportunity Commission Act, as well as similar acts in each state. This legislation marked a change in principle. Human rights became not common law rights or even universal declaration rights that could be vindicated against the state. Instead, they became rights that could be enforced by the state or by citizens against other citizens and private corporations. I suspect most of the controversy about human rights concerns legislated rights that affect dealings between private individuals and private companies. And one might doubt that Eleanor Roosevelt, in her work for the Universal Declaration, had in mind that it might be used to force a baker to make a cake for a gay wedding. She might well have thought common civility and manners were the best means to encourage neighbourly and decent behaviour, not mandatory injunctions and compensatory awards. If the state takes control over interpersonal relationships, it starts to leave no space for the exercise of individual virtue. At the beginning of the present century, in Jones and Scully, Justice Healy of the Federal Court dealt with a claim against a retired school teacher who'd been born in Russia during the war. Mrs. Scully was in court to meet an allegation that she had breached the Racial Discrimination Act by distributing anti-Semitic literature in letterboxes in Launceston and selling and offering to sell such literature in the public market there. His Honour concluded that the material Mrs. Scully distributed conveyed imputations, and I quote from the decision, that Jews are anti-democracy, anti-freedom, pro-tyranny, that Jews do not have a legitimate claim to Palestine as they are not true Israelites, that Jews are alien leeches who have bled off trillions, and the theme of one of the leaflets was that many of the world's problems were attributable to international Zionist Jews. His Honour found that Mrs. Scully had engaged in conduct rendered unlawful by Part 2A of the Racial Discrimination Act, and she was restrained from repeating or continuing that conduct or selling or distributing publications to the same effect. I thought about Mrs. Scully because some of the statements in the material that she distributed seem to have returned to social media and to public demonstrations since the attack by Hamas on 7 October last year. As the Australian Holocaust survivors noted in an open letter marking the 85th anniversary of Kristallnacht, a senseless and virulent hatred of Jews is one of the world's oldest and most contagious viruses. It seemed to me that the Jew haters and the useful idiots who give them cover and make them feel comfortable marching down the streets or camping on the campuses really have no natural immunity from that plague. And those who oppose the continued existence of Israel have far too easily and readily allied themselves with those who oppose the continued existence of Jews. Bizarrely, groups like Queers for Palestine support and work to entrench the rule of a regime that persecutes lesbians, gay, bisexual and transgender people. And unlike the West Bank, where same-sex acts were decriminalised when they were occupied by Jordan in the 1950s, the Hamas-ruled Gaza has a criminal law which makes consensual gay sexual conduct a felony punishable by 10 years imprisonment. In February 2017, the so-called Hamas Ministry of Culture condemned the novel Crime in Ramallah and called for its author, Abad Yahya, one of the most renowned Palestinian authors of his generation, to be prosecuted for threatening morality and public decency. His book is the story of 3 Palestinian men who work in a bar where a young woman is murdered. It's a thriller. One of the characters, though, is gay, and he is arrested. Although cleared of any charges involving the woman, police realise he is gay and start torturing and humiliating him for that reason. He eventually flees to France. In September last year, Hamas condemned not just this novel, but also guidance issued by the United Nations to its staff about treating all genders and LGBTI people equally in the Gaza Strip. Hamas said that it promoted deviance and moral decay. I'm also intrigued how feminists for Palestine seem unperturbed that in January last year, Hamas police disrupted a workshop organised by a women's group in Gaza City for journalists and students. The police interrogated the attendees about violations of the rules on gender segregation and forced those attending to sign morality pledges as a condition of their release. You may not know, but Hamas rules on gender segregation extend to education, and from age 9, girls cannot attend any school where there are male teachers or students present. In Hamas-ruled Gaza, single women are under the control of their fathers and married women of their husbands. In January last year, Hamas security services arrested 2 sisters, Wassam and Fatima El-Tawil, who were aged 24 and 20, at a safe house to which they had fled from a raft of horrors inflicted by their father, including beatings, death threats, and confinement in a locked room for 35 days. Hamas handed them over to their parental uncle to return them to their father in Rafah. One of the sisters sent Amnesty International a message. It said, "We are doomed." They've not been heard from since. But, sorry, I diverge. The most recent human rights developments in this country are more, as I say, legislative than constitutional, but they are also of a different nature to the ones that were enacted commencing in 1975. In Victoria, Queensland and the ACT, there are now charters or bills of rights in application by state law. Could I mention just one aspect of these? Perhaps in an unacknowledged tribute to the common law presumptions and the principle of legality, these acts include interesting interpretation provisions. The courts are instructed to interpret past and future legislation in a way that is consistent with the declared human rights. Now, you will know that the traditional statutory interpretation question is, what did Parliament intend? By these legislative instruments, the courts are now to decide how many toes may be cut off the ugly stepsister's foot in order to fit it into Cinderella's glass slipper. To be frank, there seems to be a laziness in these interpretation provisions. It is as if the Parliament could not be bothered to consider and enact laws reforming their own past legislation, or to reflect more carefully on their future legislation to take seriously the responsibility of making laws consistent with human rights. Instead, it is the courts who are to decide how the legislation should operate. Now, perhaps it does not go as far as to say that existing statutes are to be reformed in the manner the court decides, because that might be a breach of the separation of powers. But it carries many of the risks that have been identified in constitutional bills of rights. Those risks, as expressed strongly in past papers to this conference, were likely part of the reason that a constitutional Bill of Rights has been rejected by voters in this country. Can I return in a very final comment to this issue of intersectionality? Aristotle says that rational inquiry in politics and ethics, and even rationality in action, requires membership of a community that shares allegiance to some specific conception of the common good. Where there are competing conceptions of that, there will be conflict over any modification of legal rights. And sometimes the conversations are difficult because the same words mean different things to different people. Last Wednesday evening, I attended a forum hosted by a university bearing Sir Samuel's name. There, two legal academics spoke about what they called the anemic two-sidedness of universal human rights. They rejected it as probably merely another aspect of the possessive logic of colonial oppression. One speaker held to a kind of woke version of class-based analysis. In other words, that only the oppressed have rights. The kulaks can be slaughtered. Due reference was given to intersectionality. Now, in fairness, the point of intersectionality may not be to interpret or understand the world, but to change it. But the complexity of its challenge is such that in a recent American podcast, it was thought best to leave the change required by intersectional analysis to a big new woke supercomputer capable of identifying each multiply challenged person or class and arranging them in a hierarchy of oppression, with the more multiply oppressed having a right of priority over those less multiply oppressed. Whatever intersectionality may be, there is no doubt that it is a popular academic topic and that it is penetrating, one hesitates to say colonising, other disciplines, at least gauged by the papers given at the November conference and the presentation this week. If you recoil at the idea of having AI or a supercomputer identify whether you have rights or not in competition with others, you might find some comfort in the words of the critic and writer Laura Feigl. She reminds us how dangerous it is to reduce human life to manifestos or formulas. She says, lives and experience demand richer forms of storytelling. Thank you.